Good morning, everyone. It's great to see you. Better weather than last month when I was here. We looked outside at one point and we could not see out the window. The fog was so dense. So there's that going. And it's not frigid cold, right? So win-win. I'm Michelle Rick, and it's really great to be with each of you this morning. And of course, for me to be with my colleagues, Judge Yates and Judge Mariani. I'm particularly privileged that I have this opportunity to sit here in this moment because this is my last time I get to sit with Judge Yates, as he will be leaving the court for brighter, greener pastures. And it has been such an honor and privilege. I don't know Judge Yates as well as maybe even some of you do, but we've had the opportunity to work together in the Michigan Judges Association. We did committee work. You know that court rule on foreign language interpreters? We were part of that back in the day. You have left a remarkable legacy here at the court, and it's just it's a bittersweet moment, most definitely. But
thank you, Judge Rick.
Absolutely. Judge Mariani, is there anything you want to roast him or anything?
Feel free.
Yeah, open mic.
We have 2 days.
We do, yes.
He'll save his best material for tomorrow.
That makes sense. But anyway, in all seriousness, you will be missed. And for those of you who are arguing, you will see the beauty of Judge Yates' writing in some, if not all, of these matters. And that's another thing I admire so deeply about you, Judge Yates, is just, you know, obviously you have drive, you have compassion, you have work ethic, and you also have the ability to write poetically. And it is, your talents are extraordinary. And one other thing I'll say before we get down to the business at hand. The first matter waived, by the way, so I'm using their 30 minutes. But the other thing I would mention is that very recently, one of your former clerks from when you were on the trial court became my friend on LinkedIn.
Really?
She did. And we had a brief exchange about you, and what was apparent is just the love, admiration, and respect anywhere you go, and you earn it. So, yeah.
Thank you very much, Judge Rick.
Thank you. All right, now down to business. This is panel 1 of the February 2026 session. And I know that many, if not all of you, have been here previously, so I will not spend too much time going over the particulars. We're going to give you an opportunity to do what you need to do here today with your case and on behalf of your clients. But having said that, know that we've read everything. We have people in our office and in pre-hearing who have read everything. And so we're very familiar with the facts of your case. If you can focus your arguments accordingly on the briefed materials and the legal reasons that you believe your client should prevail, that will help us immensely. The only other thing I would indicate is that to the extent that we have any matters involving children, survivors of domestic violence, sexual assault, or other individuals whose names don't need to be repeated, we ask that you don't. On the record, you can use initials if you don't mind. These matters are being recorded and will be uploaded to YouTube on a later date. So I appreciate that. And with that, I'm going to start with case number 1, docket number 372870, People versus Winston Kirkley Jr. This matter was scheduled for oral argument and by defense counsel, and she has waived. Therefore, we will submit that matter on the briefs. Moving second to docket number 373369, First Medical Group versus Progressive Marathon Insurance Company. Looks like we have 2 attorneys who are endorsed for argument both on defense side. Welcome. Okay, and Mr. Gould, you aren't endorsed, but we'll take your appearance and you are looking at me quizzically.
Yes, Your Honor, this is something I should have called sooner, and I do apologize for checking for my panel today. I noticed that it had, did not show me what the full argument. I was a little confused why I was trying to figure out the filing of the appellant's brief initially was late. However, there was a motion to extend filing and it accepted as time to grant.
Okay. Well,
If the court wishes, to abide by me not being endorsed, I'm happy to just listen. And if you have any questions,
do my colleagues have any position?
I think probably what would make sense is we'll have some questions for you, perhaps on rebuttal.
I perfectly accept.
Right, because
Yes.
opposing counsel is endorsed, I know that.
Yes, thank you. Again, Judge Yates, invaluable. I appreciate it. Please, you can approach, and there's only one attorney then for defendant.
Right, my
Okay.
colleague is in attendance. But,
Okay, terrific. Put your appearance on the record then, counsel.
David Kinzer on behalf of defendant Progressive.
And you can proceed.
I think this is a very simple case. I'll try to take as little of your time as possible. The injured person, that's Mr. Kevin Baytops Jr. He's not the name insured on the policy. His mom, Ms. Gillis Baytops, she is the name insured. The policy also names her husband, Kevin Baytops Sr. So initially there might have been some confusion about that. But because the injured person, Mr. Kevin Baytops Jr., is not on the policy, plaintiffs must prove that Mr. Baytops was living with his mom on the date of the accident.
But just to be clear, let me see if we can get this sorted out fairly quickly. The question's where he's domiciled. What's your position on where Kevin Jr. was domiciled?
I believe that all of the evidence on file indicate that he was domiciled in Detroit and that the mom was living in Wixom at the time, at the policy address.
And of course, a person can only have one domicile. And so
That's right.
in your view, that would then be mutually exclusive.
That's right.
Why is residency not a relevant inquiry? I mean, these are 2 different things. Policy speaks to residency, at least to some extent, right? Or you tell me.
So I don't think that there is any evidence that the mom and the son lived at the same home. And the home on the policy, where the only home named on the policy is the one at Wixom.
But I guess, counsel, just to my legal question, it seemed like from your brief, you just said, well, they're not domiciled or they didn't share a domicile or a residence. And I guess is your position that it doesn't really matter for purposes of this appeal?
What matters, Your Honor, is that whether or not he was domiciled at the Wixom address, and there is no evidence of that. That's the address that is named on the policy. There is appellants never made the argument that the residency in Detroit should be insured in addition to the Wixom. At least I didn't understand that from the brief. And so I think that that is the relevant inquiry, is whether or not he is domiciled at the address on the policy with the mom.
What's your position on the internal claim notes? Because in my effort to try to figure out what's going on here, it all seemed really muddled, particularly if you take into consideration the internal claim notes, because there seems to be some significant evidence there that the mom and Kevin Jr. were living, domiciled, whatever you want to say, at the same place.
But with the important addendum that not any evidence that they were domiciled at the Wixom address named on the policy.
Right.
If the mom isn't living at the Wixom address, then the policy was fraudulently procured. But we're not taking that position because we believe that the mom was domiciled in Wixom and that the son was not. As for
Take that position, counsel, but the evidence still is what it is. So if we have evidence of record indicating that perhaps she was living someplace else and, you know, the address on the policy was wrong for one reason or another, what do we do with that evidence? Why does that become irrelevant to the dispute? I understand what your position is, how chosen your path there, but we still have to deal with the evidence that we have. So why does it not matter that there's apparently conflicting evidence in the record about where she was actually living?
The posture of the case is not that we are looking to invalidate the policy. We are fine with the policy being insured at this point at the Wixom address. That is what the insurer agreed to, and we're not taking the position that that is not, that was fraudulently procured.
Yeah, follow that logic though, because I'm a little bit concerned about going down that path, because it seems to me that if she were domiciled in Detroit, you might very well have a fraud claim in terms of procurement of the policy in the first place. But Kevin Jr. would be an innocent third party. And so you'd have to go through the rescission analysis with respect to him, right? I mean, the balancing of factors and all that.
Hypothetically, yes. I don't think with the evidence on record. So
Right. But my point is, if she committed fraud in procuring the policy, that's not preclusive of his claim or the claims through him, right? I mean, here we have providers, of course, but.
Right, we'd have to do the innocent third party analysis, and
Right.
we've not done that. And I think that the evidence on record is not that the policy was fraudulently procured, right? If you're referring to the claim notes.
Yep, I am.
So there's only two conversations in there between the mother and the progressive representative, and plaintiff appellant leans very heavily or exclusively focuses on the first one. This is on page 137 of their Bates labeled brief. And it starts out after Ms. Gillis Baytops confirms the policy address. Then the representative then asks her about this house in Detroit on Cedar Grove Street. And Ms. Gillis Baytops, she says it's her father's home and he lives in Detroit, but she goes there a lot too. And her son even lives there and she owns her father's home. And actually she lives there in Detroit too. And then the progressive rep stops her and says something like, I thought you said you lived in Wixom at the policy address. And Ms. Gillis Baytops says she does live in Wixom at the policy address. Quote, kind of went round and round with name insured regarding physical residency and injured uninsured residency at time of loss, end quote.
Seems like that creates a fact issue.
As to her residency, which is not the relative inquiry at this time of the case, but it could hypothetically create a fact question, right? She then immediately says afterward that she lives at the address in Wixom and not at the resident, and that her son lives at the residence in Detroit, right? It is irrelevant for the policy whether or not the mom spends time, how much time she spends caring for her father at the home in Detroit. That's not what we're concerned with. And the conversation ends. Rep asked who lived there, referring to the policy address. Name insured said she did. Rep asked where injured uninsured lives. 15475 Cedar Grove Street in Detroit. And that's how the conversation ends. And there's only two conversations after the accident. That's the first one, begins and ends confirming the policy address.
It's curious to me that a hearsay objection or argument has been made where it seems that both parties are relying upon those notes. Can you address that, please? Are they hearsay or aren't they?
I think that there is a strong argument to be made that they are hearsay. But even if they're not even if they're not hearsay, even if we consider them, we have this one conversation where at one point she says, mistakenly or not mistakenly, that she lives at the home in Detroit, which she could live at the home in Detroit as long as she lives at the home in Wixom. And we don't have any evidence that she doesn't live at the home in Wixom. And then in the second conversation, the mom has a singular definite position. Son has nothing to do with her address or her policy. Son doesn't live with her and hasn't for years. And I think that is strong evidence in this case that for the position that we have and that we care about, the only relative inquiry, which is whether or not the son lives at the home in Wixom. And if we don't consider that, if we believe that they're hearsay, then there is no evidence creating a question of fact about whether or not the son or whether or not the mom lives part-time in Wixom, right? There's no evidence or lives part-time in Detroit. If there's no hearsay, then that is, there's no evidence that she does that, but it's not a material fact whether or not she spends time in Detroit or how much time she spends in Detroit. That doesn't matter.
Do we have any other questions for counsel?
Okay.
No? Okay.
I think there's just one other thing that I want to bring up, which if we do take the position that this is a material fact and that the evidence should be considered, that Ms. Gales Baytops, representing that she lives at the policy address in Wixom, or she spends time in Detroit and then she's back at the residency in Wixom. So there's a case law saying that a party's ever-changing and uncorroborated account, end quote, is insufficient to raise a genuine issue of material fact. That's D'Ambrosio v. McCready.
But you just said that it doesn't matter for her. So reconcile your arguments, because it seems like you're taking a different position than for this.
I believe that it doesn't speak to a material fact. And I do think that that is the strongest argument. I do, on the other hand, if we believe that it's not hearsay and for some reason we are interested in it, I don't believe that the evidence that at one point she said this after she said in a contract that she lives in Wixom, and then that she says later positively that she lives in Wixom and that her son doesn't. If we think that that matters, that's an ever-changing and uncorroborated account, and also wouldn't matter for that reason.
Thank you.
Well,
I
there's
think
no other
we've-
questions.
No, I think we've got it. Thank you, counsel.
Thank you very much.
Does anyone have questions for Mr. Gould? Shall we give him a couple minutes,
Yeah,
maybe?
I'd like to start him off with a question, if I may.
Of course, Your Honor.
Explain to us exactly where you think Kevin Jr. is domiciled and where his mother's domiciled, and why we should accept that understanding of where each one of them is domiciled.
Well, I think at minimum, they're both resided at the Cedar Grove address. I think there is certainly a question of fact as to the domiciliary, perhaps of Miss Charmaine Gillis Baytops, but Kevin Jr., all records, including his license, medical information, things of that sort, show the Cedar Grove address. Why we should accept that is putting aside the hearsay statements, whether or not they are or not. There's other facts from the claim notes that I do not believe would be hearsay that would clearly create a question of fact before they ever.
But in order to create a genuine issue of material fact, you have to show that his mother lived at the Detroit address, correct? Not Wixom.
We would have to show that there is
I mean,
a question of fact
She
aspect, yes.
can't be both places. She has
she
to
cannot be
one or the other.
domiciled at both
Right,
places.
right,
That's correct.
right. There can be one and only one domicile, right? So explain what evidence in the record establishes that his mother was domiciled at the Detroit address.
It would be her statement saying that she lives there, as well as their own internal investigation before speaking to her, where they flag that we have a garaging issue because nothing is pinging to that Wixom address. Everything's pinging to the Cedar Grove address. And then shortly after all this goes down, Ms. Charmaine leaves Progressive, gets a Liberty Mutual policy. This is less than 6 months after the accident. Everything is listed, including the vehicles, at the Cedar Grove address, and she lists that's where she's living at that time. I just want to make clear, we're not making the claim that there's no factual dispute. We're not
Right,
saying 100% that she is done. We're just saying, that the motion should have been denied because there's clearly a factual dispute based on her statements against each other, as well as defendant's own investigation that shows that there was issues.
And what's the reason we can look at the claim notes as substantive evidence?
I think it's a two-edged sword. Either if we don't look at the claim notes, at least the statements of the named insured, because I don't believe all the claim notes are hearsay. I think statements of defendant on their own investigation in there would come in either as a party opponent statement, where they're not recounting someone else's, they're just their own conclusions and investigations. As to the named insured, Ms. Charmaine Gillis Baytops, I think many of her statements, especially to defendant, would be hearsay. I think plaintiff using them can be hearsay, but I think there would be some exceptions, specifically when she's stating that she lives at the Cedar Grove address with her son, maybe a statement against pecuniary interest. She calls on later to say, hey, my premiums have increased. Why? And they tell her because there's a claim open, and she goes, no, I don't live there. And Kevin doesn't live there. There shouldn't be a claim. So she originally makes a statement. It causes her a financial loss because her premiums increase, and then she recants the statement. So I believe there would be I think it is hearsay, but I believe there would be an exception, at least for that statement.
Right, because one would assume that the premium's lower if she uses the Wixom address than if she uses the Detroit address, right?
I don't believe there was any any facts, but I believe so.
Right,
Most
that's
likely.
a setup for the next question,
Yeah.
because the question is, let's assume that she committed fraud in the procurement of the policy. You still get the benefit of having rescission analysis, right? So you don't just lose because your providers, but your claim is through Kevin Jr., not through Kevin Jr.'s mother.
Correct. And there would actually be, and I don't know if this has ever come before the Court of Appeals since the Motor Figueroa case, but there would actually be two levels of innocent third-party analysis.
Right.
One would be to Kevin Jr.,
That's exactly
and then
right.
a second would be as to my
You've got
clients
an
as medical
innocent
provider.
third party stepping into the shoes of an
Innocent
innocent
third party. Yeah, so there would actually be two steps of analysis on that one.
Right.
Whether or not there's any material difference in that analysis, obviously, that's not something I'm ready to brief today or argue to the court.
Counsel, can you answer the question I posed to the counsel in terms of domicile or residence? What is the relevant inquiry?
Well, what I would say in terms of the relevancy of this case is that if the court finds there to be a question of fact as to either, I believe that the motion should, or the lower court should be overturned. Because if I'm not mistaken, and I should have the progressive policy right in front of me, I believe they extend benefits to resident relatives. And of course, under the MAP, the progressive case, this court held that residency is different from domiciliary. And is expansive of that term. So if the court found there to be a question of fact that she at least resided with him on the date of the accident, then the motion should have been denied in the lower court as well. So it's.
I mean, for Kevin Jr., it's a resident relative. But what about her? The relevant inquiry for purposes of her, policy where she resides and where she does.
Specifically for her, I'm reaching back here, but I believe we have appellate decisions that say, policies insure people, they don't insure addresses. The inquiry for her on where she is domiciled or residing would, I think, simply go to whether or not she committed fraud. She's not claiming any insurance, any coverage here. So there could be the case where, rescission is proper against her and there's no coverage to her, but there's still coverage to her son based on being a resident relative. The inquiry should be whether or not he resided with her. It's regardless of where she is resided at any given time, as long as he's residing with her or domiciled with her, I believe he would be covered under the policy.
And he was 19 when he.
That's
incident
correct. I
happened,
believe so, Your Honor.
All right. Thank you. Thank you, counsel. Appreciate
Sure.
it.
And thank you for allowing me a short rebuttal when I did not catch that mistake early on. I do
That's all
apologize.
right. We appreciate you being here and we appreciate the dialogue. So thank you both. Well briefed and we'll have you a decision shortly. Next, moving on to item number 3 on the docket. This is case number 370174, Estate of Stacy Marie Jenkins versus Ascension. Good morning, counsel.
Morning, Your Honors.
You can place your name on the record and you can proceed.
Thank you. And good morning. My name is John Malone. I come before you this morning on behalf of the estate of Stacy Jenkins. There are 3 legal issues before the court in plaintiff appellant's brief, and the cumulative impact of those legal issues that were had on the trial that occurred in Wayne County in this case.
They're all evidentiary issues subject to abuse of discretion review, right?
That is correct, Your Honor. However,
Reserved, but abuse of discretion.
However, at least one of the claimed issues, I don't think there's any dispute that there was an abuse of discretion. It was a clear legal error. The other 2 issues as well were legal errors ultimately, and as a result of an abuse of discretion. The first evidentiary issue identified regarding the inability of plaintiff's expert to offer a calculation of the HEART score, which is a risk stratification tool used in emergency departments to determine whether or not an individual should be discharged, go on for further testing, admitted, or a whole variety of other outcomes.
But your expert said that the heart score is not within the standard of care.
But
And I
defendants,
think she said she doesn't even use it or calculate it often.
she testified that she does use it when she's teaching in the emergency department, residents who utilize the HEART score as part of their practice. Significantly, while plaintiff's expert testified that she does not personally utilize the HEART score as part of this risk stratification, defendant's emergency medicine expert in the case, both before trial and during trial, unequivocally testified that the HEART score is the standard of care. Plaintiff should have been permitted to offer testimony from her expert, contrary to the testimony of defendant's expert regarding the calculation of the HEART score.
But if it wasn't in the record, and if I remember correctly, your expert, actually, it was the defendant who indicated that there was no recollection independent of the record of her interaction with the decedent. Is that correct?
Yes, Your Honor. That was one of the significant issues in this case, and one of the reasons why these evidentiary errors that are brought before the court today were as significant as they were. This was an instance where we were relying almost entirely on what was contained in the medical records for a recounting of what occurred during this emergency department presentation. The defendant emergency physician claimed to have no memory of the presentation. That's understandable. She had seen a lot of patients since then. Plaintiff's decedent, the only other individual who was present during the presentation that could have offered her side of the story, wasn't present because she's a decedent. And so that created a significant issue in the case in regards to plaintiff's ability to show evidence contrary to what was contained in the medical records. And these rulings significantly undercut plaintiff's ability to do that with admissible evidence that would have clearly shown that some of the contents of the medical records at the very least should have been questioned by the jury.
But it also seemed to me that she significantly downplayed what was happening to her in real time to the treaters. I mean, at least the records, like the doc walks in and is like, I'm fine, can I go home?
Well, but what we have is not what Stacy Jenkins said. We have what's in the records. And what came out in trial was that effectively there was this understanding that Stacy Jenkins' symptoms were clarified by the medical providers that she was speaking to, that she didn't really present to the emergency department with chest pain, even though she was a 38-year-old nurse who stopped driving in the middle of running errands to say, I need to go to the hospital because I'm experiencing chest pain. The presentation given by defense in this case through Dr. Yatuma, the defendant, and through their expert was that Stacey Jenkins wasn't really experiencing chest pain when she stopped driving at 38 years old as a registered nurse and said, I'm experiencing significant chest pain and I need to go to the hospital. Plaintiff was then undercut in their ability to present evidence of Stacey Jenkins doing exactly that.
Isn't Judge Rick right when she says that once she was in the emergency room, she really downplayed the significance of what she was experiencing? I don't know what the medical professionals are supposed to do if she says, I'm feeling fine now.
There is a question as to the degree to which she downplayed the significance of it, or the extent to which what's contained in the medical records regarding this downplaying of the significance could be or would have been consistent with what she was experiencing before she went to the emergency department. And
Right,
so we
but
were left with only the version of events recorded in the medical records, which was the whole problem in the first place. There was a question of the quality of the history taken.
but in that moment, counsel, what is this doctor to do when the facts are she's a nurse? What are they to do? They don't have that backstory. They've got what's in front of them, and she is minimizing, if not dismissing, based on the notes.
There's also a question, Your Honor, not only of the note, and again, the note is the recounting of the defendant emergency medicine physician. That is a filter from whatever it is that Stacey Jenkins relayed in the emergency department. There's also inconsistencies amongst the records themselves. When she initially presents, there's recording of chest pain, 5 out of 10 chest pain. That diminishes over time. However, again, there is a question. One of the claims in this case was the extent and the quality of the history taken by Dr. Yatuma regarding both the reason why Stacey Jenkins was presenting to the hospital in the first place and her family history of cardiovascular disease, both of which are issues before the court right now.
Yeah, can we move on to the family history? Because I know you spend a lot of time on the on her mother's cause of death. Would you mind saying a few words about that?
Yes, Your Honor, absolutely. The significance of the mother's cause of death specifically, and why the jury should have been able to hear from Stacey Jenkins' family members who testified that the family understood Stacey Jenkins' mother to have died of a heart attack in her 50s, is that in the medical record from Stacey Jenkins' presentation to the emergency department, that in this case, there is a segment of the record where there is a question regarding family history. The response, as recorded in the record, was that her family history was non-contributory. Family history, in the context of assessing somebody for risk of possible unfortunate upcoming cardiac events, a la the heart score or similar risk stratification, one of the things that's specifically taken into account is a family history of heart disease.
Right, but in order to prove that, you have to present evidence of it. Now, if the death certificate had been admitted, and I think it probably could have come in, then I think you would have had a perfectly reasonable argument for cause of death. But I think what you were trying to do was get it in through the relatives that she had died of some sort of heart complications, right?
Well, because, Your Honor, the import of this testimony that Stacey Jenkins' mother and that the family understood, including Stacey Jenkins, that her mother had died of a heart attack in her 50s, was that on the one hand, there was a presentation being made that there was an appropriate history taken in the emergency department. Stacey Jenkins was asked, do you have any family history of cardiovascular disease? And she responded, no, or that there was a non-contributory history.
Right.
What we were attempting to put forth in terms of evidence was that Stacey Jenkins, based on the family's understanding of the circumstances of their mother's death, would have understood, if she had been asked that question, that she did have a contributory family history of cardiovascular disease.
Right.
It is contrary evidence to show that that question was never asked, that history was never taken, despite what's in the records, because the records don't necessarily indicate whether or not that question was ever actually asked or answered.
Maybe I'm misunderstanding how you framed this issue, but I thought what you wanted to do was get the cause of her mother's death in through the statements of family members. And you were prohibited from doing that, and that you argue is an abuse of discretion, right?
Correct.
So the problem I'm having is that strikes me as rank hearsay. And I don't see how 803.19 helps, because it seems to me that the family can report on the fact that she died, the day that she died and all of that, but they can't offer essentially under 701, I guess. I don't know what it'd be, that she died of some sort of heart complications. I just don't see, I don't think 803.9 gets to that. I think all it gets to is just the basic facts of marriage or death or something like that.
The language of 803.19, I would contend, does fully support the admission of this testimony.
And well, there's no Michigan case on that, but the federal courts disagree with what you just said.
But the language specifically of Michigan Rule of Evidence 803.19 does support this testimony. The language of the rule specifically says the reputation of the person's death and similar circumstances. Well, how someone died, a family's understanding of how someone died. You know, my grandmother died of cancer. My uncle died of a stroke. My mother died of a heart attack. That is the family's understanding of the reputation surrounding that individual's death.
Right, but I mean, here's the problem if you allow that sort of thing in. There's a death certificate that records the cause of death. And the cause of death could have been reported as cancer. And the family members say, well, you know, we thought she had a heart problem. That's why she died. Now, that's why I don't think 803.19 does what you want it to do.
One of the issues here, Your Honor, is that the question of how Stacy Jenkins' mother died, her cause of death, was not an issue that plaintiff had to prove in this case.
Sure.
It was not an issue before the jury. It arguably, this whole issue is non-hearsay because it was not being offered for the truth of the matter asserted.
But if
in the
that's
first
true, it's
place.
irrelevant. If it's not being offered for the truth of the matter asserted, it's plainly irrelevant.
It is relevant because it's being offered for Stacy Jenkins' knowledge, her understanding of the family reputation, which is directly relevant to the question of whether or not she was asked, do you have a family history of heart disease? If she knew that her mother, her understanding was that her mother died of a heart attack in her 50s.
Okay.
Any other questions? Nope. All right. Anything else you'd like to add? You'll have time for rebuttal.
Thank you. I would just briefly touch on the third issue, the inability to offer testimony from Stacy Jenkins' sister, Tanya Jenkins, regarding the statements made by Stacy Jenkins on the way to the hospital.
And that's a fairly simple point, because I think there's a concession that that was error, but other witnesses were allowed to fill in that gap in the evidence.
So I think, and this is why I wanted to bring this point up specifically, Your Honor. There was another witness that testified and offered testimony regarding statements made by Stacy Jenkins on the way to the hospital. I don't think it can be fairly said that that evidence would have been cumulative of the evidence that would have been offered by Tanya Jenkins.
But I think, I mean, we probably can have a more intelligent discussion about this on rebuttal, because I think they're going to concede that you're right, that Tanya Jenkins should have been allowed to answer that question.
And I think that they are based on their briefing. However, they extend that argument to say, even though this may have been an error, it didn't matter because, as you alluded to, they're arguing that this information came in through another witness.
Right.
However, plaintiff was precluded for presenting this testimony from the only available live witness to do so. The only other witness testimony that the jury heard to this effect was from an individual who predeceased the trial. Their deposition testimony was read, and deposition testimony of questioning by defense counsel regarding statements made. However, the individual that was actually riding in the car with Stacy Jenkins in the back seat after she started experiencing chest pain on the way to the hospital was precluded from offering that testimony. Furthermore, this ruling made by the trial court regarding this testimony being inadmissible hearsay, any statement made by Stacy Jenkins is hearsay. That was the trial court's ruling. That ruling came after any testimony that the jury heard regarding statements made by Stacy Jenkins on the way to the hospital. That poisoned in the mind of the jury the admissibility of any of that prior testimony, because as far as the jury was concerned, they had just been told by the judge, this is inadmissible. Any statement made by Stacy on the way to the hospital is inadmissible.
Thank you, counsel. You'll have time
Thank
for
you,
rebuttal. Mr. Cook. Good morning.
Please the court, Michael Cook on behalf of the defendants, Appalese, Ascension Emergency Medicine Specialist, and Dr. Roma Yatuma. I don't want to belabor the point on anything. I think my brief covered the issues. It seems like you have a firm grasp. I'll try to rattle through them real quick. If you have questions, obviously, please stop me.
Would you mind starting with issue number 3?
Yeah.
Because that's concerning.
Yeah. So on issue number 3, I think it's really important that the jury heard the testimony. The argument that you just heard about an objection ruling later on somehow preserves and reach back and strikes all the prior testimony is sort of new to me. I've never heard that. The jury heard all this prior testimony is unobjected to. Another really important point on this is just before the objection and the question that was sustained, Tanya Jenkins did testify that her sister said she had chest pains. It's on page 97. And that's when you're talking about Stacy experiencing chest pain that caused her to pull the car over, correct? Yes.
And that
It
drew
wasn't
that drew no objection.
That drew no objection. It wasn't until additional questions on the next page that drew the objection that was sustained. So the jury heard it from Stacy. The jury heard it from Duquesne's testimony. The jury heard it from multiple experts. That's cumulative evidence that one, which I've acknowledged. I think that objection should have been overruled, but that's not the type of thing that we reverse the trial for, right? Moving to the second issue, I think that issue has been waived. The trial court's ruling was based on Leavesley and the idea that lay witnesses can't testify to the cause of death in a medical situation like this.
Right.
Judge Yates, I think
Personal knowledge.
yeah, I think your questions around this, and that's why the hearsay stuff is really sort of relevant. It's, can these lay people say she died of a heart attack? And the judge, I think, very astutely pointed out she could have died from a lot of things. She could have died from pulmonary embolism, which, you pass a class, something like that. It might look like a heart attack to somebody. They can't say what caused the death.
And there are a couple ways you can prove it. I mean, you
Yeah.
can bring in an
Sure.
expert to testify, either a treating physician or an expert,
Yep.
or you can put in the death certificate. A
Yep.
death certificate would have been admissible, right?
For the mother, probably. Yeah, I
see how it would
I
be.
can't stand in here and think of a reason
Right.
that they would have been able to keep that out. Yeah, honestly, I can't. So,
I mean, it's a public record.
right.
I don't recall. Sometimes these things pop into my head as we're having argument. But were there any motions in limine run? Because, looking kind of at that high level down on these facts, it seems to me that some of, these evidentiary issues, had they been run as motions in limine and decisions made, would have.
I don't know the answer. These specific issues were brought through motions to eliminate. I didn't go back and check that
Okay.
primarily because all the arguments are geared at trial objections.
Yeah.
So I'm
Okay.
guessing, and honestly, Mr. Malone, I know is trial counsel. He can probably correct me if I'm wrong
Awesome.
at that. But everything's been based on the objections during the trial. So that's been my focus of the ruling.
It just seems that the pathway is clear to everybody if, from a practice perspective, that these issues could have been flagged ahead of time and maybe
Possibly, yeah.
potentially resolved. I'm just looking
You
at
have
it from
more
a different
experience with
vantage
it
point.
than I do, but I have seen the cases where there are like 30 motions to eliminate filed, and it gets a little tedious about how they're going through.
That's
Yeah.
true.
It can.
Micromanaging the trial before it happens. So I don't, where do you draw the line on how
Right.
fine, to tee
Right.
it all up beforehand? Doing appeals, I certainly appreciate the opportunity to brief it beforehand, keep everything out in front of you, but I
Fair
don't
enough.
do trials, so.
Counsel, what to, I guess opposing counsel's point that, the truth of the cause, the point isn't what she actually died. The point is what, would have been in the decedent's mind when asked, did you have any family history that could have been contributory? So what's on the, why is that not a different inquiry?
Sure. So I think it's really important to consider what they did get to put in front of the jury. the jury, and they did get to say that the mother had heart issues. Arguably, I think that might go a little bit too far in terms of what they were allowed to do, but they did get that in front of the jury. They did.
Go to the error, or does that go to the harm?
Well, I think it goes, that it's part of the harmless error analysis, certainly. But I do think it illustrates the point that I want to make in terms of why the specific testimony of she died from a heart attack wasn't admissible. So the concept of she had heart problems, pretty vague, pretty general, not specific medical testimony of this is the cause of her death, right? And where the trial court drew the line was these lay people cannot say what was the cause of the death. And, you know, doing medical malpractice work, the sort of established principle is causation in medical malpractice cases requires expert testimony. And I think that really underscores the point of why it is appropriate for this trial court judge to say, no, they can't say that the heart attack caused her death. What they did get to say was she had heart issues and she died at 54. That let them make the exact argument they wanted to make, that Stacy Jenkins was aware of her mother's heart issues. She died young. So somebody who knew that would convey to this doctor, yeah, my mom had heart issues and died young. They still got to make the exact same argument. It's just without that last connection, which I do think is appropriate under Leasley and Howe, in the case that the trial court actually relied on, say, no, these lay witnesses can't testify of what caused the mother's death.
Well, is the problem then one of personal knowledge under the 600 series? Is it opinion testimony under 701 that shouldn't have come in? Or is it a hearsay problem, or is it some or all of the above?
I think it's probably, honestly, probably a combination of all the above. But if I were to really try to pinpoint it, I think it's the difference between lay and expert testimony.
So 701 versus
Qualification.
702.
Yeah. I think that it's really, they just weren't qualified to say what the cause of death was.
But I guess that may be so, but you know, I they could be totally wrong about the cause of death. Actually, kind of. But aside the point, if that's what they thought, you know, that's what she thought the cause of death was. For whatever reason, all the family said, you know, she died of X.
That's clearly wrong. The birth certificate says why. But everybody, that's just the family lore. So when they go to the hospital and they report their medical history, they say, and you know, that doesn't get borne out by the truth of circumstance ground, but it's nonetheless what they say and what maybe would be reflected on the medical chart, which I think is point. So I guess why is this not so much of the side of, you know, the fact that these people aren't qualified to actually tell you why she died is one thing, but you know, that's not, I guess, exactly what it sounds like they're trying to say.
Sure. So I guess, you know, abuse of discretion review, I think the trial court made a principled ruling of why he wasn't going to let them go that far. He did let them go pretty far in terms of saying she had issues, and they were able to explain their exact argument to the jury on that point. So if we're going to, you know, cut it and say, well, they could have been able to allow to say it because they weren't really saying she actually died of that. We just think she died of that. I think it's abuse of discretion review still supports the trial court's ruling. In addition, it's still harmless error. They got to make the exact same argument that they wanted to.
Well, and I was also struck by the fact that none of the proponents who wanted to offer this testimony had remained with her in the hospital room. So again, I have to question.
Yeah, well, it is ultimately, you know, a question of fact for the jury of what
Right.
she relayed, right? We have the medical record, we have what we know about her, and ultimately that was for the jury to decide what she relayed, right? We're not here to relitigate that. We're just dealing with these evidentiary issues, and none of them really have direct bearing on that, in all honesty.
They may have been talking back at the family gathering about grandma's heart, but it doesn't mean that that sentiment was ever conveyed in the room to the treater.
But she did that in the moment with the treater.
Yeah.
Exactly.
Yeah.
If there are no other questions on that second issue, I'll move to the first issue, which is the heart score. I think really important. Plaintiff's expert testified that wasn't standard of care. Defense expert testified that the standard of care didn't require her to do it. Neither standard of care expert testified it was required for her to do it. So her saying 4, and we all know she was going to say 4, right? She established if it's 3 or less, you go home. If it's 4 or more, you stay. She was going to say 4. That wasn't relevant, and it certainly wasn't essential or critical to the case. It didn't make a difference. I think the trial court made the right ruling in terms of her saying that calculation when both of them said the standard of care didn't require it was correct. It's abuse of discretion. It's certainly arguable, right? That ruling. And then again, her saying 4 was not it was a harmless thing, right? The jury certainly knew what she was going to say. They eventually ended up going through the entire hard score anyways. And I don't think anyone in that courtroom had any confusion about how the plaintiff thinks it should have been scored or would have been scored. So to me, right ruling, use of discretion, harmless error. That's my argument on that issue. If you have any questions, I'm happy to address.
No more questions. Thank
very
you.
much. Judge Yates, thank you for your service. You've been on the court of appeals for a little bit now. I've had you on a few panels, not as many as I would have liked, but just from your reputation, both in the circuit court and while you've been here, really thank you for your service to the state. I don't know what the greener pastures are. I'm sure they were wonderful. We will miss you.
Thank you. That's very kind of you.
Rebuttal.
Thank you, Your Honors.
Yeah, can you address that, the issue of, am I correct factually that none of the proponents of the testimony that her son or others remained with her in the hospital room, that they would have conveyed that to the treatment providers? Am I correct about that?
You are correct that Stacy Jenkins went into the hospital by herself.
Right.
If I'm understanding your
I
question.
am.
correctly.
And so I guess the fact that everybody knew, in addition to potentially, there being a hearsay concern, I don't know that is even that the fact that the family knew isn't relevant as to what transpired in that room when she presented for care.
The fact that that was the family's knowledge of the reputation of their mother or grandmother's death, that the relevance of that, the importance of that information is that goes to understanding that the other family members were not in the room to relay that. Stacy Jenkins was. And if the testimony and the evidence was going to support that that was her understanding of her mother's death, that was the important thing for the jury to hear. That was the
I'm extrapolating from the fact that maybe his other family members thought this. How do we know Stacy shared that belief?
well, her son testified at the trial and would have been more than capable of testifying that that was her mother's understanding of the circumstances of his grandmother's death.
Right,
However, that
would
testimony
have been
couldn't be
rank
offered.
hearsay. I mean, the problem is, and I think Judge Rick hit on it perfectly. There were 2 people in the room when her history was taken, right? She was there. Obviously, she can't testify. She passed away. And then the person who took the history. Had anybody else been in the room, then they first could have reported on the conversation. And second, I think as Judge Rick pointed out, they might have piped up and said, hey, she hasn't mentioned it yet, but her mother died of heart difficulties.
Part of the problem here, Your Honor, is that based on a lack of any firsthand memory or accounting from Dr. Yatuma, the defendant, regarding this presentation, her interactions with Stacy Jenkins, and our inability to offer Stacy Jenkins' testimony of her memory of what occurred, we don't know whether or not there were any questions ever asked relating to her family of history of cardiovascular disease. If there were no questions asked, that was a problem. That was something that plaintiff was claiming was a breach of the standard of care, regardless of what the record stated about being non-contributory, because the whole crux of the argument is if she was asked, she would have reported a contributory history. And so based on that, it calls into question whether or not she was ever asked the question in the first place, despite the content of the record.
And unfortunately, we're stuck with that record. That's the evidence or lack thereof that we have. And again, it's kind of a best practices rather than solving this case, but it's just unfortunate that no family member stayed to ensure that that information was conveyed, but we can't inject that information into the record. The trial court can't inject that based upon this reputation information that was ever conveyed.
The question can be put before the jury as to whether or not that question was ever asked based on evidence of the fact that if it had been, Stacy would have reported it based on her knowledge of her mother's death.
Okay. I think I understand. Anything else you want to indicate for rebuttal?
Yes, just briefly regarding the issue of the reporting or the inability of Tanya Jenkins to fully testify regarding the statements made by Stacy Jenkins on the way to the hospital. The significance of that error and her inability to fully testify regarding the statements made by Stacy Jenkins to her on the way to the hospital cannot be downplayed. One of the central issues in this case, as we've already discussed, was what did Stacy Jenkins present to the hospital for? What was she reporting in the hospital? And there was an effort made during the trial to explain away the significance of Stacy coming to the hospital at 38 years old with chest pain so significant that she stopped what she was doing and went immediately to the hospital. The significance of that, what she was feeling, what she was experiencing on the way to the hospital would have been best offered to the jury through the testimony of Tanya Jenkins. And that would have been the best evidence plaintiff had in contradiction to what's contained in the medical record and the testimony of the defendant and the defendant's experts, which explain away and downplay the significance of her presentation.
Thank you very much.
Thank you, Your Honor.
Appreciate your argument. Your briefs were excellent. We'll have an answer for you shortly. This matter is submitted.
Thank you, Your Honor. Thank you, Judge Yates.
Thank you.
Thank you very much. Appreciate it. Thank you so much.
We are going to move on to item number 4 on the docket, which is docket number 371972, Shar Ann Shoni. I will need assistance with the last name, and I apologize. Shonia versus Marcy Hunt. Shania, thank you. And we have both counsel endorsed for argument. You're Ms. Kapadia. Thank you. Have you seen or heard from opposing counsel, Mr. Mine? Okay. Oh, interesting. My docket says endorsed for oral argument. Well, I guess, Ms. Kapadia, if you want to take the podium, anything you'd like to indicate in response to the appeal as you represent the appellee.
Good morning, Your Honors. Again, my name is Simone Kapadia and I represent defendant appellee Marcy Hahn. There are just a couple main points that I'd like to reiterate for the court this morning regarding, there's a number of issues that before the court this morning. There's the summary disposition issue. There's the issue of amending as well as other issues. I'd like to focus my argument this morning on the trial court's grant of summary disposition in Ms. Hahn's favor. One of the first reasons that the trial court granted summary disposition was on the issue of proximate cause. The reason regarding that is that Ms. Shania's essential main arguments during this case were that her ex-husband during the underlying divorce proceedings hid an undisclosed interest in entity known as Dry Medic Restoration Services. Discovery in this case established that Mr. Sean Shania did not own an interest in Dry Medic Restoration Services.
Right. And just to be clear about this, the affidavit and the supplemental affidavit from Mr. Hassano really resolves that question, right? I mean, there's no evidence on the other side of what he says.
That is correct, Your Honor. There's no evidence establishing that Mr. Sean Shania ever held an interest in dry medic restoration services. He held an interest in dry medic restoration novi, which he disclosed during the divorce proceedings. And one of the other items that I would like to bring up regarding the issue of proximate cause is also the protection provisions in the judgment of divorce, namely on pages 20 and 23, which is the good faith provisions, the asset disclosure provisions, as well as the verification provisions. And really the essence of those provisions are that even if Mr. Sean Shania misled or hid assets in the divorce, that the proper remedy for Ms. Shania is to seek remedy through Mr. Sean Shania, not through defendant Marcy
Just
Hahn.
reopen the divorce.
Right.
Correct.
So, and that could still be done presumably.
As far,
I have no idea how the statute of limitations affects an effort to reopen a divorce judgment, but
Right.
presumably either that opportunity was had and lost by the passage of time or still exists, right?
yes, and I would say that it's a contractual breach that would be the potential claim.
It's 6 years. The statute of limitations
going off of-
ordinarily for breach of contract is 6 years.
Going off of memory, I think so. That's correct. And again, as far as I'm aware, Ms. Shania has not taken any action against Mr. Sean Shania.
She might have to move within a year to set aside the.
Yeah,
judgment.
I don't know. That's such a strange thing. I'm not really sure what form that would take because you're right. If it's under the effort to set aside the judgment, that may
Right.
be totally different.
But if
Unless there's fraud, and I think there
Right.
is, yeah.
or if it could be a breach of this contractual terms if he wasn't, regardless, the point is that it's
But they
not.
built in their own remedy.
Right, exactly. And it's not, the remedy is not through Ms.
It's not
Ms.
Ms. Hahn's fault.
Yes,
Mhm.
that's correct. And then,
Right.
and then the other, one of the other main points that Ms. Shania makes during the underlying case, during this case, excuse me, is that the issue of spousal support. In the mediation, the parties attended 2 days of mediation in January of 2021 as well as in March of 2021. And then the judgment of divorce was ultimately entered in April of 2021. And in the mediation summary, Ms. Hahn, on behalf of Ms. Shania, did indicate that Ms. Shania was seeking spousal support. And Mr. Sean Shania's represented attorney indicated that he was not entitled to pay spousal support to Ms. Shania. And essentially that during the process of the negotiations that the parties had in mediation, the ultimate judgment of divorce did not include the term of spousal support. Ms. Shania acknowledged this willingly during the judgment of divorce itself, as well as in the judgment of divorce hearing proceedings. And so on the issue of whether or not, there's nothing here indicating that Ms. Shania was forced to settle the case or that Ms. Hahn wouldn't have taken the case to trial if that would have been the benefit of Ms. Shania. And then
You don't get to amend your complaint. Let me help you. You don't get to amend your complaint if you don't say things properly and don't have anything to complain about.
yes, Your Honor, I agree. I believe that the amendments that Ms. Shania proposed were futile, as well as and then regarding the evidentiary issues as well, I believe that their abuse of discretion standard, that I believe the trial court arrived at the right outcomes. I'll rely on my briefing regarding that. If there's anything that the court would like to ask this morning.
Sounds like we understand and we're good to go. Thank you for being here, counsel.
Thank you very much.
Appreciate it. We'll have. Thank you. Okay, that is consistent with my understanding as well. Thank you for that. This matter will be submitted. Leaving next, item number 5, docket number 372543, Jawad Shaw MD versus auto owners versus Automobile Club Insurance Association. Hello, counsel.
Good morning, Your Honors. I don't know if you thought I was Sarah Nadeau, but I'm not. I'm
Okay,
Daniel Saylor. I did actually see that although my name is also on the brief, I never filed an appearance. So this morning we did file an appearance.
that's terrific. Thank you, counsel.
Thank you. And this will be brief. I would come up and say I'll rely on my brief, but I can do better than that and rely on the published opinion that came out in Favo versus Brown this fall. It directly addresses our issue. And it was the same argument in that case, the same issue, which didn't have an answer. Now it has an answer. And I was pleased that the rule established is the one that we've been arguing. So I would just refer the court to slip opinion, page 7, that really answers the question that, in fact, the MPPR rule is a rule that, unlike the example stated in the statute, it is related to rates in the Medicare fee schedule. But the ultimate question being in the statute is, what is the amount payable under Medicare for this person? And so unless there's questions, I guess I don't have anything more to say on that. I would say that the trial court motion was filed as a motion for partial summary, but I believe that that was converted into a motion for summary because there were anesthesia bills as well, but I think that was conceded in the district court proceedings. So that left only the MRI bill with the application of the MPPR rule.
But just to be clear, I mean,
Yeah.
if we rule in your favor, and it seems we really have no choice, however we feel about it, it has to go back to be cleaned up, right?
I suppose that would be
I
true.
mean, I can't figure out any way that we could finally end this case by reversing and just leaving it as is.
And say summary disposition should have been.
Right, I mean,
Yeah.
I think there has to be.
Let the
judgment of
district
some
court
sort.
do that if that's the case, right? So, right, and that would be fine. The only other thing I would say, if I may, Judge Yates, is that I echo everything that Mike Cook said.
Thank you, that's very
Uh,
nice.
And I in particular want to thank you for your authored opinions, because I joined Judge Rick in saying that you bring a real freshness to your writing. And I love the way you start your opinions. It just brings the audience right into the story.
Thank
And
you.
I will miss those. And thank you for providing us with those.
Thank you, that's very kind of you. Thank you so much.
Thank you, counsel. You have time for rebuttal?
Good morning, Your Honors.
Morning.
So,
It's
Appearance
tough
for the
argument.
record.
Tough argument to make, but go ahead. Put your.
Jonathan Green on behalf of the appellee here.
Thank you.
Before we go any further, there is one other issue here which is kind of interesting. The same day that FAVOT was argued, I was before this court in front of Judge Rick and Judge Letitia and Judge Bazzi, and Mr. Saylor was there as well. And we argued an hour before FAVOT was argued. And so, okay, I see the guys in the hallway afterwards, chit chat. And so FAVOT has come out, but we have not gotten an opinion on our case. So again, I'm somewhat ignorant as to, you know, the machinations of everything going on in the Court of Appeals, but I am assuming that there is discussion or something is going on because because of this opinion. So I don't think the door is entirely shut. So that being said, I do want to address the FAVOT opinion here. I understand that it is on appeal. Again, it's not something my office is handling.
There's been an application filed.
Application. Thank you. But really, I think the fundamental thing that is being, I think, overlooked here is that the whole point of the No Fault Act, and I cited it in my brief, it's the Miller versus State Farm, is to minimize administrative delays and factual disputes that would interfere with the goal of expeditious compensation of the claims. I think all we're doing is adding more and more complexity to this thing, which I think is contrary to the entire purpose of it. And as I read FAVOT, I'm really having a difficult time because I think they made several jumps that.
Your position is FAVOT's wrong. Not that it's different, that's that it's wrong.
Yes.
Okay.
Right, and whether Soapy Williams would be turning over in his grave seeing what happened is beside me, right?
But
No doubt he would be tremendously upset at what no faults become.
it's you know, I liken no fault to when you spill water on a glass tabletop. Have you ever tried to clean it up with a sponge? You end up just chasing the water around forever and ever. And that's kind of where we are with this. And so with the changes to the section 3157, I think we're finding really where they've thrown a wrench into the work to the point that I'm thinking it's almost unworkable.
It's not all bad though. I mean, you have a provider suit here. You didn't have provider suits when we got started.
We
That's
get an
something.
assignment.
I know, I'm teasing you.
No, I understand. And frankly, I didn't think we needed assignments because we really weren't assigning, rights to payments, or rights to services or benefits as such. But regardless, the thing that I'm having an issue with FAVA, and I'll read it here, is that they said, while the second clause of MCL 5315750F, 15F provides that if a fee schedule is involved and other adjustments unrelated to the rate in the fee schedule would be made under Medicare, those adjustments are not to be considered for purposes of the No Fault Act. It did not state that there could not be another applicable method for calculating the amount Medicare would pay for a service. So just stopping right there, they were basing all of this on the, I forgot the name of the case, the Central Home Health Care case. And remember, Central Home Health Care specifically said, we're not dealing with the manner of calculation. Do they pay for it or do they not pay for it? If they pay for it, you go based on either the fee schedule or based on the fee for service. I forgot what they called that there. But it wasn't talking about the manner of calculation. So to say that that provides some support for the idea that that it allows for the application of Medicare rules is absolutely incorrect. It doesn't track. So the problem is, if we're looking at the multiple procedure rule, in particular, everything is related to is not related to the rates in the fee schedule because the numbers are the same. And what the courts have done uniformly up until FAVOT is they said, well, look, the rates in the fee schedules are sacrosanct. The amount of reimbursement is a rule, and we don't apply those. And that's the easiest way to do this. That is in keeping with the whole point of the No Fault Act.
Well, are you asking us to call for a special panel to resolve a conflict, to create a conflict and then resolve it ourselves?
I think there is a conflict, and again, my ignorance of the workings of the Court of Appeals, but I think there is a conflict. I suppose at this point, and maybe with the case we had before, maybe a conflict can't be called until there is an opinion issued.
But you can always write an opinion calling for a special panel. We've re-energized that process in the last few years. All of a sudden, it's back again.
That's no wonder you want to retire. But as I look at this here, because then if we look at the definition that they have put for this, okay, they say, yes, we look at what Medicare pays, but then we have 15F. How are we supposed to reconcile the fact that it provides a definition of Medicare, and then it says without regard to the limitations unrelated to the rates in the fee schedule? Well, isn't the multiple procedure production, the fee schedule is the same. It's just we're going to pay you less as our rule. What do you do if there's not a fee schedule? And to be quite honest, there really isn't a fee schedule. A fee schedule is a thing. It is a list. So the problem is this. What most people do, myself included, is, okay, the No Fault Act only requires reasonable proof of the fact and amount of loss. You don't have to use a CPT code. You don't have to use a form or anything. But they're going to say, well, we want a code. So you say code 1234. You go on the CMS website and look up 1234. Well, what happens when it says we don't pay anything for 1234? I'm telling you, 9 times out of 10, you can't find what it is. Medication. We know Medicare pays for medication. I can't find it. So you know what everybody has been doing? They figure, well, it's usually close to average wholesale price and just
Oh,
something
don't
that-
get me started on AWP. I
Okay.
came from the AG's office and yeah, that's a whole other nightmare.
So the thing is this, they've really kind of turned this into a hash, and I'm reminded of the old helmet law, the motorcycle helmet law, because what they had at that point is it said you had to wear a helmet that was approved by the state police. The state police didn't approve any helmets. Okay. And so they said, well, they said you can have a DOT approved helmet. Well, the DOT doesn't approve helmets. Okay. So what do you do when you have something that frankly is unworkable? Okay. And, I think frankly, I mean, this is a bit of a, I'm going to say, a radical thought, but maybe this provision is something that can't be worked with. The rest of it makes sense. You have to charge a reasonable amount. That's 3157.1. You have to charge a reasonable amount, and that's where we were before. And if you can't fit through 2 or 7, or if you weren't in business 5 years ago or 6 years ago, or however many years ago it is now, you're back to sub 1 anyway. So somewhat of a radical thought, but maybe this is not something that is workable at all. But regardless, what they're saying is that if it changes the amount of the reimbursement, it is related to the rates, and it isn't. Because if that's the rule, then everything is related to the rates. So, interesting one to have. Thank you very much, Your Honors.
Thank you.
Thank you, Mr. Green.
You have time for rebuttal, Mr. Saylor.
I won't use much. I recognize now we're debating things that are probably beyond the court's ability to address right now. But number one, it's not as complicated as the provider bar, I'll call them, would like to say. There are thousands and thousands of providers that get paid by Medicare, and they have to accept or work out how much does Medicare pay. And that's all we're doing, now, and this is obviously a legislative issue, not a court issue. The legislature is the one who decided, how can we do something better in terms of a tangible cap rather than the vague, reasonable, and necessary, which is, factually amorphous. Instead, they said, well, let's adopt something that's objective for a cap. They could have chosen the workers' comp schedule. I don't hear a lot of hue and cry about that, other than it's not very much. But they didn't choose that. They chose, well, how about let's go with what is payable under Medicare? It doesn't say, let's go with the fee schedule rate from Medicare. They said the amount payable under Medicare. So you just figure out, well, what would Medicare pay? With the caveat, it doesn't say, well, and we also have to say that everything's related to the fee schedule. It says, no, you only exclude those limitations. And they gave 5 good examples of what they mean by unrelated to the rate and the fee schedule. And those things, as the Favreau case explains, are these very totally unrelated things about like punishing hospitals for too many readmissions for the same problem and everything. And then it's more of a global reduction on what they can recover from Medicare. It's not a percentage of a fee schedule rate. How could you have something more related to a fee schedule rate than you take the fee schedule rate and pay 50% of that? It's true, it doesn't change the fee schedule rate, which seems to be the argument here. It has to change the fee schedule rate to be related. Well, how can you change something that's already written down? It doesn't have to change, it has to be related to it. This is related, as the Favreau court explained. Let me see if there's anything else. Well, counsel made the statement, maybe it was misspoken. He said, well, there is a conflict. Well, there is no conflict.
Not
It's
yet.
not yet.
Not yet.
Okay, so there is no conflict yet. And I don't know what's, going on with precision, but I'm sure the court will issue an opinion on that at some point. Maybe wait till after the leave is denied or who knows what. But in any event, unless there are any questions. One more point about the central home. The Favreau case did not base its opinion on central home. It ultimately, what comes out of it is that the central home opinion, which is not controlling, it doesn't address this issue, I acknowledge, but it is the result, and the commentary in central home is fully consistent with the result and commentary in Favreau. And in my view, the 2 cases, both published opinions, provide some much needed guidance in this, and we're working it out. Obviously, this is still working its way through the appellate system, getting some decisions. But this whole fee schedule stuff, unless it's legislatively changed, is becoming clear as we go. So unless there are other questions, I will leave it with you.
No, thank you very much, counsel.
Thank you. Have a good day.
You as well. This matter is submitted. And are we up to the break?
Break.
Oh, we're going to take a short break. We'll be back. All right, everybody, welcome back. For those who are new, we are moving on to the 11 o'clock docket for panel one, this February 2026 case call. And just a brief reminder, if you have cases that are of a sensitive nature involving children, victims of domestic assault, or domestic violence, sexual assault, please just use their initials and we'll get right underway. Calling item number 7 on the docket, which is docket number 373581, Faison versus Highland Park. And it looks like we have Mr. Parks endorsed on behalf of Applee. Is that correct? Do you want to put your appearance on the record? And I think we're clipping along so well that if we have questions for you at
Absolutely.
rebuttal time.
Absolutely. And that's what, yes, Ann Gabbard on behalf of the city of Highland Park. And I came to answer any questions, so I will sit tight. Thank you.
Thank you so much. And you are Mr. Parks. Good
Peter Parks,
morning.
appearing on behalf of Willie Faison, who's seated in the courtroom.
You can proceed when ready.
Well, it's a little awkward as a appellee who's beginning the argument, but I can pretty much indicate to the court that, you know, I'm sure you've read all the briefs and I've tried to cover things at least initially in the appellee's brief that I thought were germane. Now, they filed a reply brief and I hadn't been able to obviously respond to that. Hopefully the court has received a copy of the Webb versus Wakefield Township case.
Yes.
I'll be honest with you. How I found that case, I don't even want to tell you, but I was trying to prepare for today on Sunday, and I was doing a search of some of the cases that were cited by defendant and stuff, and I see a reference to this case, and it was like 100 years old. I almost didn't open it, and I said, I'll open this thing. And I got it on my search, and I go, oh my gosh, this is like almost like our case. I mean, it involves, on top of everything else, snow plows, dump trucks, and the issue of, you know, whether or not a person who is not technically the authorized person perhaps to represent the township in that case, and here the city, if the city has reaped the benefits of the products or the equipment as they have in our situation here, it's unjust to have the city benefit and then a person like Mr. Faison just be completely without any kind of legal remedy.
And now they've driven it into the ground and they're like, oh, it's yours. Come pick it up.
Come pick it up. Well, and you know, I can't really testify as to what we think the status of that one truck is, but it
Sounds like it's a clunker.
well, it actually it might not be. There's could be a lot of reasons the city
Okay.
of Highland Park is not using it, but the bottom line is I don't know if I can add too much more. I think Webb versus Wakefield is right on point. I do believe that there is a distinction between the one case that I thought the defendant cited that I wanted to like speak to was the Knights of the Iron Horse versus the city of Detroit. That case, the claim was that there had been a relationship between this entity, Knights of the Iron Horse, in the city of Detroit. They had been supplying them actually trucks to be used, in connection with some highway work or whatever, and they were being paid a certain amount of money per truck. They wanted to upgrade the trucks and get better trucks, but only if they could get a commitment from the city of Detroit that they would continue to utilize those newly purchased trucks and pay at a higher amount per day than what they were receiving from the older trucks. And so based upon that, like, representation, they committed themselves to purchasing more trucks for their company, believing that the city was going to continue to contract with them into the future, 30 months in the future or something to that effect.
Mr. Parks, can I ask you a fairly technical question?
Yeah.
I would start with Ms. Gabbert with this question and see what she has to say, and then I'd turn to you. But unfortunately, this is an inverted argument. So
It is.
I'm going to ask you because this is our one chance to ask you questions. This case is here on an appeal of right, not by application, right?
Right.
And so it looks to me like the only reason that they could bring an interlocutory appeal is because they're claiming immunity under the Governmental Tort Liability Act. So it'd be a C7 grant of summary disposition. But to buy that argument, you have to believe that the two well-pleaded claims in this case somehow are not what you say they are. They are instead a negligence claim. And I think that's the only thing that's in front of us. If we strictly enforce the right to interlocutory appeal for a C7 ruling.
That's actually a good point. And my first,
Well, I read this last night and I thought, why is this case here? And then I realized, oh, they must be here on a C7.
my first note to myself was about the governmental immunity argument that,
Right.
they're saying that my claim is a negligence claim. I never pled negligence at all. I mean, I used,
Right. And I'm
as a
sorry that you
record-
have to go first instead
No,
of
no,
second,
you
because
know,
I would
that's-
ask Ms. Gabbard, how in the world can this be a negligence claim?
it's clearly not. And,
So I think I don't know how much we can write here, but it seems to me the only thing that's really in front of us is whether you pleaded a negligence claim. And the answer is obviously not.
no, I did not. And as to everything else, at the very least, there's a factual dispute about all of the other potential elements that they raise. So
Sure.
maybe
Okay.
if you have any other questions, I guess I can respond, but I'm pretty satisfied with what has been submitted along with the web case. I just glad you guys were able to review that,
And girls too.
consider it. I apologize.
That's
We-
okay.
We were just instructed.
Right. Don't say you guys.
I apologize. That's
You're,
okay.
you're all right. I make that mistake myself from time to time. Thank you, counsel. Anyone have
Gabbard,
questions
Would
for
you
Ms.
mind
Gabbard?
standing up and answering my question? I have no earthly idea why this case is here on interlocutory appeal. None.
Well, Your Honor, so what is left of the claims is promissory estoppel and unjust enrichment.
Right.
And
Right. What happened to by the way, was the statutory conversion the basis for circuit court jurisdiction because of treble damage and attorney fees or something?
I believe so. Yeah, I mean, it was never in federal court
Because-
and
Right, it's a $10,000 claim. Everything about this case jurisdictionally baffles me. What was going on in the circuit court?
Same,
What's
Your
going
Honor.
on in front
Same.
of us?
same.
Okay, so
Yeah,
tell me why you're here on an appeal.
Yeah,
of
so
what?
and the city obviously, you're exactly right. And, yes, it is, we're only here for our interlocutory at this stage under GITLA. And our position is under promissory estoppel, there is case law that says it can be akin to a contract claim and a tort. And so the tort would get us into GITLA. That's 1200 6th Street. That is in my brief. That's a 2012 case.
Right.
Our position is that I don't know what relationship Mr. Faison had with the mayor, but the mayor did not have authority to do this. And
Right, but that wouldn't be in front of us anyway at this point, would it?
well, if it was
I mean,
to the
you
point
only
that
get you only get to come up on the immunity issue.
Yes.
What does that have to do
Yes.
with immunity?
to the point that if assuming arguendo, and I don't want to put my former mayor in a box, but assuming arguendo, what his actions were negligent to permit this to happen. And Willie knew that it was something, Mr. Faison knew that it was something that could not happen. And it happened twice. No. The mayor, just as a point of record, just so your honors know, and it was a concern for me. What I'm told is he's either had a severe stroke. I'm not sure if he's even still alive. He was not deposed. So in that sense, and I get that the plaintiff's, deposition transcript does count as part of evidence, but I don't have anything from the mayor even saying truthfully that this even happened.
Right. I mean, this is just a pet peeve of mine, and maybe it's because I'm sitting on the Court of Claims now, but every single time we deny summary disposition, if they threw in any kind of C7 request for immunity, they think the whole case is in front of the Court of Appeals. And it just doesn't work that way.
So, yeah. Well, again, whether we get down the philosophy as to the immunities of municipalities, but because it is something that is permissive, that was our position.
Right. Okay. So your position is one or both of these claims are negligence claims.
Correct.
No.
Oh,
Choose.
well, it would be,
One or both.
right, the promissory, so unjust and promissory is what's left.
Right. Yeah.
And promissory, the unjust, no, I don't think that I could have came up on this unjust.
Okay. So no matter what happens, the unjust enrichment.
I still think that it was an unjust enrichment, but for this court's purposes, correct.
Okay. That's fine. Thank you.
Anything else?
Yes, I wondered, am I correct that the city utilized the vehicle long after Mr. Faison left its employ?
Not long after, I think for maybe a year. if
Okay.
that. And so I guess to your
How-
honors,
Does that not conflict?
is this for the unjust argument or?
I'm just going to pose that very broadly
Okay.
because frankly, these facts don't add up. So help me see that in the
Well,
universe
so-
we're talking.
As far as we have the promissory estoppel, which to your honor Gates' position, I believe is what puts us here. I do believe the unjust enrichment is not a valid claim as well. The unjust enrichment has to be that the municipality, yes, they had use of the dump truck, but were they aware of the days of the goings on that dump truck was being used? I would put it towards the court that they were not. Because when contracts are validly gone through the city council, anything over 4,000, they either do a bid or they don't do a bid depending, and they have to assess what it is that they're buying. So I can't say that the council was aware that in the city of Highland Park, these 2 dump trucks were being used because it was never in front of their desk. So for them to say, because what he has to show, what plaintiff has to show for unjust enrichment is that for a municipality, specific to municipalities, is that they were aware and they were consciously using it. Mr. Faison was the director of public works right up until basically the dump truck died. So he left, I think in like 19, and then the dump truck, died in 2023. I don't know the exact dates, or 2022.
Yeah, I thought he left in 2022.
Yes. And then I think the dump truck was not a great dump truck to begin with. It was only
Counsel,
10
I
grand.
mean, these are maybe these are trial arguments,
Mhm.
but we're here on your motion.
Yes,
for summary.
and that is, I guess that was, but to your honor Rick's point as to the city using it and that sort of thing.
Yeah.
But
Just seems like it's also convoluted factually.
no comment.
Thank you. Okay. Any other
Thank you.
questions?
Thank you.
All
No,
right,
thank
thank
you.
you. This matter will be submitted. And Mr. Faison, it's always nice to see litigants. Thank you for coming, sir. Thank you for coming. Moving on to item number 8, docket number 373594, Marion Elder versus Baker Propane. And hello, counsel. Who are you?
Good morning. No, guys. Fred Lucas appearing on behalf of Baker Propane.
Thank you. You haven't heard from her?
Well, she tried to file an amended brief about 3 days ago, but
Okay, we'll check with our court officer. She has not checked in. Is there anything you'd like to say? If so, take the podium, counsel.
Yeah, you have to come.
take the-
We
yeah.
won't. Yeah, we won't pick it up at all unless you're on the microphone. Thank you very much, Mr. Lucas.
Nothing other than it's a lovely day out. I'm not going to bore you and waste your time. My brief says it all. I don't think I need to go into anything. If you have any questions, glad to answer them. Otherwise, I will.
I
let
have
you move on.
one question. Is the
Yes.
propane tank still on her property?
Yes, we tried to go pick it up after the trial and she was out there with a shotgun. So at this point, I think the propane tank is a lost cause, and frankly, the problem I have in this, and if I may just editorialize for a moment. This is an example of a situation where my client has suffered greatly as a result of the cost that we've been put through to try to recover what should have been a very simple matter. But it is what it is.
But the propane tank presumably is of no use to her anymore. It's
No.
such an odd thing.
She
If
could have
you
someone else
haven't,
fill it.
Yes, oh yeah, I suppose that's right.
Yeah.
what's that? You're
Sorry,
right.
that's a
If
good
you have,
point.
if you have a competitor, the competitor could fill it.
Oh, they could fill it, but the competitor would also bring out their own tank too.
Oh, they would.
Yeah.
Ah.
It's just like what happened with this one. You bring out they brought the tank out, they filled the tank. And it was getting paid for, they continued to fill it. And then once you stopped paying, they were gonna come out and get their tank. But any other competitor would have done the same thing. This is not a tank that she ever owned, so.
Thank you.
But thank you very much. Have a
Thank you
great
for
day.
being here. This matter is submitted. And we will move on to our next matter, KB versus Bessie Mae Somerville.
Good morning, Your Honors. Matthew Payne appearing on behalf of the plaintiff appellant.
Good morning. You can proceed.
You know, this is obviously very heavily factually based appeal. I know the court is extremely familiar with the facts, not only from 120 prior appeals, but on this one, this is the first time the court actually called and requested the video of the deposition of the physician, which isn't really even a crux of what's on appeal. So I know the panel is extremely well versed in the facts. All I really want to add this morning is that I understand that this is a very significant and difficult burden to meet, but the reason why new trials and JNOV exist are because of cases like this. I will also concede that I probably wouldn't even be here if the jury had answered yes, that Ms. Somerville was negligent, but then found KB more negligent when they got to the comparative questions. I think the fact that the jury said Ms. Somerville was not negligent at all evinces that no reasonable person could agree with that conclusion.
Well, but isn't one of the problems that there's really no evidence on the other side because KB doesn't remember anything? It's not KB's fault, but KB has no real knowledge of how the actual collision occurred, right?
That's a wonderful question, and very directly, the best evidence is Ms. Somerville's own testimony.
Okay, so you think just based on her testimony alone that you're entitled to relief on appeal?
20 miles per hour without hitting the brakes.
Right.
The fact that he was on a mini bike played no part in causing the accident whatsoever. The tree did not obstruct her view. She saw him 4 or 5 houses down riding toward her. Okay. I think that, and I don't know why I didn't stop was ultimately her answer. And I sort of want to, I didn't bother filing a reply brief. But I do, my theory at trial, this is not based on Ms. Somerville's license being suspended a few years later, or not even about a year later, because she failed her eye exam and then she continued to drive. That's not my theory at trial. Regardless of her age, regardless of her ability to drive, she was very simply negligent. And then one thing I want to add, even though it wasn't brought up in Appellee's brief, is
Before we move on, then I have a question for you. And that is, I see there is conflicting positions that you've taken. Because at trial, you opposed the motion for directed verdict, saying there were issues of fact. And then subsequently, the JNOV, you're saying the jury got it wrong as to that element and these facts. So it seems to me you're trying to argue both sides.
well, obviously, Your Honor, I'm going to argue that minimally there is a question of fact when I'm talking about a directed verdict motion before the defendant's proofs, right? So that was,
Right, but
my
then
position was
that's
not
your
there
position.
is a question of fact. My position was there is at least a question of fact. I don't think those conflict at all. I think all of the evidence shows that there really is no question of fact that Ms. Somerville was negligent and the proximate cause of KB's injuries. I believe that, but of course also a subset. It's almost like a lesser included offense if you want to talk about criminal law, right? I can also say, well, minimally, there's also a question of fact. And that's all I was really trying to do. Just making sure I made that point as well.
Because of the procedural posture of the case.
Exactly. I'm not going to put all my eggs in one basket. To win that directed verdict motion, all I have to do is show that there's a question of fact. And honestly, at that point, there were probably more questions of fact. It wasn't until Ms. Somerville testified and admitted all of those facts that I just listed and had no explanation for why she ran over KB.
Where was that motion argued? Well, like the transcript.
Close of your case in chief, should
Right.
right?
Before.
Right.
Hadn't all the testimony been argued?
Oh, yep. I made a mistake. I believe I did call Ms. Somerville. I believe I did.
Oh, I see what you're saying. So it was entered at the close of your proofs, but you called her as an adverse witness.
I believe I did.
I mean, if I remember right, it seemed like that, and then there was, I think, maybe one witness from the defense, and then the
police officer.
The directed verdict was argued after all of the proofs have been submitted.
I believe that's correct.
So
I apologize.
I guess to Judge Rick's question, then, I mean, we're kind of in that posture. You're before the court, and you're saying this should go to a jury, and now you're coming to us and saying this shouldn't have gone to the jury. So I guess that's I understand your general point about how you would kind of handle a directed verdict, but like I guess translate that to the circumstances here where you came before the court with all the proofs submitted and saying fact question. And then you're coming to us and saying, not really a fact question. There's no way the jury could have come out this way.
To be completely candid, I had a lot more time to review the transcripts and make the arguments on this appeal as I did at the end.
No, I understand the realities of
The more I looked at it, the more I realized there was no fact question. And yes, I did have admittedly blinders on looking at a directed verdict saying, well, at least there's a question of fact. But here we're also asking for a new trial. That's something that's relief that this court can provide.
Great way to argue.
And yes, and again, I want to reiterate, really, there is no evidence that Ms. Somerville wasn't negligent, and the jury answered that she wasn't. Anecdotally, I didn't put this in the brief because obviously it's not something the court can actually consider as record evidence. We talked to the jury after. They said she was negligent. We all thought she was negligent. We didn't want to answer the rest of the questions on the verdict form. That's what they said.
Obviously, we can't consider that.
I know.
If that's what they said, that's extraordinary.
I've been carrying that around for 2 years now, going home from that trial. I just wanted to put it out. Of course, this panel cannot consider that. It's not part of the record evidence. But it's telling, again, what is part of the record evidence is the verdict form that said, no, Ms. Somerville was not negligent. And that's just impossible for any reasonable person to conclude under these facts. Finally, this court, I'm sure, is very familiar with the Zenny versus Anderson case that nobody cited, 397 Mich 117. Part of defendant's theory at trial was he shouldn't have been standing there. KB shouldn't have been on a mini bike in the sidewalk. I briefed everything about the local police telling the adults that they should be on the sidewalk, that his mother told him to be on the sidewalk, that his uncle told him to be on the sidewalk, that that's safer. But most importantly, even where there's violation of statute that creates a rebuttable presumption of negligence, the facts in this case clearly rebut that presumption by Ms. Somerville's own admission that the mini bike facet had nothing to do with the accident.
Right. For all practical purposes, KB was a pedestrian.
Exactly. Any questions?
No more questions.
Just a few minutes for rebuttal, I'll save.
You've got it.
Morning, Robert Johnson for the defendant appellee. Thank you for your time this morning. A couple of observations. I'm going to work kind of reverse and respond to some of the statements made by brother counsel. I also talked to the jury, and although this court is not to consider what the jury said, the jury did not tell me that. The jury told me that it did not think my client was negligent, and that's why they found in favor of my client. Also, this trial lasted 1 day. So all these witnesses all testified in 1 day. So in my 36-year career, it's the only jury trial that I did in 1 day where this many witnesses testified. So we picked a jury, and we did opening statements, we did all the evidence, and we did closing arguments all in a matter of 1 day in front of Judge Poles. And Judge Poles had an opportunity to consider the evidence that was presented when she considered my motion for directed verdict. It's important that I point out a couple of things. One, this jury that was selected by both myself and brother counsel were told at the outset that they would be making the decision, that they would be considering the evidence presented, that they would be looking at the witnesses, listening to what they had to say, watching how they said it, listening to their voice, their tone. They had the ability to listen to all of that testimony and to compare the testimony to one another when making its decision. And I don't want to lose sight of that. This jury was charged with that responsibility. And now for brother counsel come in and say, these 6 jurors are not reasonable. That's what he's arguing. He's saying that they're just not a reasonable mind. They don't have reasonable thinking. They just came up with a decision. For what reason? What argument has brother counsel presented to this panel that this jury ruled in favor of my client, other than based upon the facts that were presented? If you look at my client's testimony, which brother counsel seemed to present most of his argument on, you have to look at it in pages 211 through 234 of the trial transcript. You can't just look at the questions that he asked and my client's response. You have to look at the totality of what my client testified. And so you have to look at her answers to my questions. And she testified that she did apply her brakes as she was entering the driveway. She testified that she was, in her opinion, driving carefully. She testified on her experience of driving in that neighborhood for over 50 years. So there's a number of things that she testified that have to be weighed by this jury when considering whether or not her conduct was unreasonable. Was it unreasonably safe in her? Did she do something that an ordinary person would not have done under the same circumstances? And I believe that there was sufficient evidence that a trier of fact could reach the decision that it did. The Supreme Court has said that this court is not to invade the fact findings authority of the jury unless the record is so clear that reasonable minds may not disagree.
So counsel, let me ask you just a question about the jury. So there's a jury instruction issue, right? And obviously how the jury is instructed affects how they're able to deliberate. So tell me why this instruction that, opposing counsel says should have been provided, why it shouldn't have been. Or do you say that it probably should have, but it doesn't matter? You better understand.
I understand the court's question, and it has to do with the instruction dealing with failure to stop in the assured clear distance ahead. The problem with the problems of that instruction is it's not applicable to the facts in this case. I believe that the Michigan Motor Vehicle Code applies to the operation of motor vehicle on a public roadway. In this particular case, the accident happens on a private driveway.
Well, I mean, I guess, but she's turning off of.
No, I understand that.
Okay.
But the instruction presupposes that Mr. Brown was in the driveway in order for my client then to stop before she strikes him. And that there's no factual record of that. In fact, the factual record suggests that he wrote, and my client testified to this, and her testimony is unrefuted, that Mr. Brown rode his motorbike into the side of her vehicle. So it's not as if he's out in front of her and therefore she should stop in the assured clear distance ahead of her to avoid striking him. He's off to her left as she's pulling the driveway.
The front of her car is already past it.
She's entering as he's coming from her left.
I understand.
And she testified that when she sees him, she applies the brakes. She's reacting. She's testifying what reasonable conduct that she took. Now, the jury could have disregarded that. The jury could have looked at that and said, I don't think that she was reasonable with her actions. They disagreed. They did agree with her that her actions were reasonable. We know that because they found that she wasn't negligent. So this whole speculation as to what would or would not have happened had they continued on is just that. It's speculation. There's a reason why the jury instructions specifically tell the jury, stop after you answer the first question if the answer is no. Otherwise, the Supreme Court would have said a long time ago, you know what, let's just have the jury answer all the questions, and then we could decide whether or not any of the answers that's provided are appealable. But that's not the case here. So in this particular situation, the jury considered the facts that were presented, the testimony. They listened to the witnesses, they viewed the witnesses, and they reached their decision. Now, what they want to do is they want a Monday morning quarterback and say, no. Reasonable minds couldn't differ on this. I beg to differ with you. 6 reasonable minds did disagree with plaintiff's assertion. They reached a verdict, and Judge Poles agreed with that when she ruled on this motion for a new trial. She found, as sitting through this trial, that reasonable minds could differ. So her ruling post-trial is consistent with her ruling during at the end of plaintiff's proofs. And plaintiffs ended their proofs with my client's testimony. That's when I presented my argument that I don't believe reasonable minds could differ, that they didn't prove that my client was negligent. It turns out that I was correct because the jury reached that conclusion. But what Judge Poles found was a question of fact. And as Judge Rick has pointed out in her questioning, so you want it both ways, plaintiff. You want to rely upon Judge Poles to keep the trial going so that you can get to the jury. But then when the jury gives its decision, you say, jury got it wrong. There wasn't a question of fact. It was so clear the jury just got it wrong, that the evidence is so overwhelming, they just got it wrong. And I disagree with that. I think this is a factual dispute for which a jury looked at it and reached a decision. They're just not happy with it because obviously it's not in their favor. And I don't think that's sufficient enough to warrant a new trial or a reversal of the court's previous rulings. Thank you
very much. Rebuttal.
Very briefly on the jury instruction issue, I want to address that. My concern here, I do think it tainted the jury to hear the defendant's special instruction, despite the fact saying the mini bike didn't matter, and not being able to hear plaintiff's requested special instruction. I think that was a huge factor in why the jury did get it wrong. And again, I'm well aware that this is a difficult burden, but I think looking at the words, looking at the testimony on the paper, in the transcripts, I don't think people can disagree. Reasonable people would find her negligent. And again, I was very limited to that first question. We're not talking comparative negligence. We're not talking about whether KB was also negligent or even more negligent. The fact that they said Ms. Somerville was not negligent was wrong.
Thank you very much.
Thank you.
This matter will be submitted. We appreciate the argument and your time today, counsel. That leaves two matters. The first of which is a consolidated set of cases, number 10 on the docket, cases 371518, 371519, and 371523. And it looks as though we've got them on both of them remotely. There we go. Terrific. Good morning, counsel. I guess it's afternoon technically.
Good afternoon, Your Honors. Elizabeth Parker, appearing on behalf of the appellant Nicholas Temples in all three consolidated matters. So this case arises out of a petition for appointment.
Hold on just a moment, Ms. Parker.
Certainly.
Do we have counsel for appellee on Zoom? I just want to make sure before we hear from you.
Yes, Your Honors. Thank you. And I apologize. My computer just crashed, of course, as the case was getting called. Don Santa Marina, appellee.
Thank you very much. And Ms. Parker, you can proceed. Sorry to inject myself.
No, I didn't realize that Ms. Santa Marina hadn't already logged in. So these three cases arise out of the receipt of $100,000 to appellant's minor children from their great-grandfather's estate. Appellant filed petition for conservatorship and sought appointment as the conservator for the children. There are two errors that we are asking this court to review. First, there was a confidential GAL report that was submitted, I would argue, in violation of MCR 5.121D2A, which requires that any interested person shall be afforded an opportunity to examine and controvert reports. Further, MCR 5121C requires that any reports are required to be filed at least 24 hours before the hearing or any other time as specified by the court. Well, here, the confidential report, a request was made for it, and that was denied. And then
Can you help me understand how was it even communicated to the court? So, were you copied on the cover letter without the enclosure? Not you personally, your client. How did that happen?
So the GAL reports, there were 3 GAL reports that were prepared and submitted and provided to appellant and his counsel. And within them, they reference a confidential report. And so that is how my client's trial counsel became aware of the fact that there were confidential reports. She emailed asking for a copy of it, and that was denied to her.
Counsel, who did she email? Or who, I'm sorry, who was emailed to request a copy?
She emailed the GAL.
Okay, and the GAL denied it?
Yes, said she was not comfortable providing that to her.
And then, yeah, I guess what happened next? Did you go to the court to say we're entitled to this and they're not giving it to us?
It doesn't appear from the record that counsel specifically asked the court for a copy of it. But if we look at the transcript and keeping in mind that this hearing was on Zoom, and I think we know things happen a little, I don't know, less fluidly, maybe is the word I'm looking for on Zoom. It's sometimes a little more stilted. From the record, it appears that the court took testimony from the appellant, then took testimony from the GAL and went right into her ruling. And so counsel below felt that she was not provided an opportunity to even make a request for the report at that point, or to even cross-examine the GAL once it became apparent that the court, referencing the confidential report, that was taking being taken into consideration. I would argue that, while certainly an objection and a specific request on the record would have been preferred, I don't think that is necessary where the language of the court rule is an imperative. It says shall, and it requires that the reports be filed. And so that contemplates that every party will have access to them and quite frankly, shouldn't have to try to track them down. So that is the first argument that we've presented, is that the trial court erred.
Sorry, in Zoom, we really have to work hard to cut in. Before you move on, let me ask you this. Is there something unique about probate court proceedings where these reports get presented to the court and not made available? Because I was on a panel 2 months ago where we had exactly the same sort of problem. It wasn't identical, but it's as close as it can get, where the report wasn't disclosed until after the hearing ended. And I don't know how in the world anybody thinks that could comport with due process.
I will tell you that in my experience, I have seen it more often than I would have thought. There is, as far as I can tell, no statutory basis for it, no court rule that permits that. Certainly, our basic adversarial system does not allow that. And so I, searched for any type of authority that would allow that to take place. And I was not able to find any.
And how does the GAL get it in the court's hands? And how does the court acknowledge receipt? This is all very foreign to us. But
to me as well. To me as well. I have not been on the side of the case where I'm the one trying to submit a confidential report to be able to say how it occurs. I'm assuming there's an email address, or maybe it's just delivered to the chambers. Nothing in the record of this case tells us how that occurred.
But that seems like it almost necessarily requires an ex parte contact.
Yes, it seems extrajudicial.
I do not get this at all, because what we were told 2 months ago in a case that had similar facts is that, well, if the people saw the report, they'd get angry. Well, that's not a basis for non-disclosure.
Right. And there are mechanisms where you can have in-chambers review. There can be redaction, but maybe Ms. Santa Marina will have some insight into this. It's shrouded in mystery.
Okay. Yeah. Sorry, Ms. Parker. I think it strikes us as very odd that this happened.
Yes. Well, and I 100% agree. I think it's even more odd when there is no one at the hearing contesting the appointment, and yet the appointment is denied based on apparently what's in this confidential report. And that really leads me into my second issue on appeal, which is, even assuming that report was somehow appropriately taken into consideration, which I don't concede, but let's just assume. The trial court's ruling nonetheless offers no basis to conclude that appellant was not competent or suitable to serve as conservator under MCL 700-54091E.
In fairness to the trial court, though, there did seem to be a great deal of concern expressed that he wouldn't turn the money over when the children turned 18. Is that not something that should be of concern to the trial court?
I think it should be of concern to the trial court, but I think we need to look at how that concern arose. There were very pointed questions. If your kid wants to buy a fancy new car when he's at age 18, are you going to let him? And I think there were questions that were designed to invoke what I would hope would be ordinary common sense that we would expect to get from our parents, telling us that might not be the best idea. And he said, I would encourage them to get an older car. And, well, what if they wanted to go play travel on a travel team and use some of the funds for that? And he said, yeah, if that's something that they're committed to, great. If they're, sitting home playing video games and this is just a lark, that's a different situation.
But I mean, that might make all the sense in the world, but it sounds to me like that's a trust. And the decedent who passed on the money didn't set up a trust. I mean, obviously, if the decedent had set up a trust and named the petitioner here as the trustee, then of course you could hold the money back until they turn 25 or 30 or whatever you want. I mean, the grantor of the trust determines that, but that's not what we have here.
No, and I think there was no indication. I mean, the court asked him, do you intend to establish a trust? And he said he'd like to. I mean, but there was no indication that he didn't plan on following whatever the law required of him. I think, if he wanted to establish a trust, he would have probably gone to counsel who would have said, we're going to have to get court permission for this. And then whether the court decided that was an appropriate thing to do or not, there's no indication that he intended to do something nefarious with this money, that he, would in no way permit his children to have the funds at age 18. There's just no basis for that, right? To ask questions that are intended to evoke a parental type of response, and then to use that as a basis to say, well, I think you're going to try to keep too much control over this money, you're going to get that response from every parent. And I think under the statute, we have an order of priority where parents take priority over a professional guardian, or a professional conservator. And, in this instance, if you have a judge saying, well, because you're expressing this intent to guide them and give them some guidance on the use of the funds, I don't think you're suitable. No parent is going to be suitable except for the one who says, I don't care, they can do with it whatever they want. I mean,
I think in fairness to the trial judge, by the time that happened, they would be an adult.
And he would have no choice. I mean, there's nothing to indicate that he would not comply with what the law tells him he has to do.
The impression, I mean, not as I read the transcript anyway, it seemed to me that the concern was when the child's the adult to put preconditions based upon one's own personal experiences, frugality, etc., that she was concerned about that because at that point they are an adult. So I just don't want to, I feel like I need to express that because I don't think it's quite as bleak. Or
Certainly.
That your client, the testimony is what it is, but ultimately, I think he made it clear, I don't drive a new car. I would not release the money for them to buy a new car. And they're an adult. So I don't know that. I think your better argument is the first issue.
Well, I think just in response to the new car thing, she asked him at age 17, would you let him buy a new car? And so, that's a little bit different than saying when he's 18, the money is his. He can do what he wants. We're talking about use of the funds while he is still the conservator. And so that's where I think, he would be ordinarily expected as a parent to give ordinary guidance. I would hope that any conservator, even a professional one, would not say, absolutely, go buy that Porsche. Here's your check. but would say, why don't we talk this through a little bit and let's see what maybe makes more sense and is more reasonable at this age. You know, something that again, like we expect parents to do this. We expect parents to give that kind of guidance, but there was nothing to indicate that he would not comply with the law and provide those funds. And certainly a fear, an unnamed fear that he will try to somehow, you know, control the children through the funds is, it's just this vague hypothetical concern, which is maybe based on something in this confidential report that we have no idea. We haven't been able to rebut it. So at the end of the day, I would ask the court to reverse and remand for an order appointing appellant as conservator and to order the production of the confidential reports.
But the way you just articulated it, aren't you putting the cart before the horse? I mean, you seem to suggest that the judge has to make the substantive decision and then turn the report over. Why isn't the more intelligent thing to do to vacate, send it back, say the report must be turned over, and then have a hearing?
I am satisfied with that relief as well. I think you are correct. Yes, I just articulated it in a way that, as I was saying it, made no sense, which is why I kind of tried to tuck that in there. But no, it absolutely makes better sense to remand for the issuance of the report and perhaps or release of the confidential report and perhaps some guidance about what is appropriate and what is not.
So when we're talking about the first aspect of your relief request, assuming it's granted, is this a pervasive issue? I mean, Judge Yates has acknowledged, he's seen it in other matters. Is this something pervasive that trial courts need published guidance from this bench?
I would argue yes. I mean, like I said, I don't handle probate matters in the probate court. I just handle them on appeal. And just on appeal, I have seen it in several cases and in cases where I couldn't envision a need for it. Cases where it didn't make sense. There wasn't a domestic violence issue. There wasn't a, abuse issue. It just didn't make sense at all. Like, at least in a case like that, maybe I can get my head around it. But as Your Honor said, there are provisions for that. You can have an in-camera review. You can do other things. So it does occur more often than I would have expected as a practitioner. And I think some published opinion guidance would be appropriate.
Thank you.
Thank you.
All right. Thank you very much, Ms. Parker. You have time for brief rebuttal. And Ms. Santa Marina.
Yes, may it please the court. Good afternoon, Your Honors. So I can provide a little bit of light to the court, being a primarily probate attorney, that in this particular county, GAL reports are submitted directly to the chambers via email. I do serve as GAL for many of the judges in Wayne County. It is usually the practice to send a copy to the petitioner. I believe that the petitioner, via what opposing counsel has said, did get a copy of the report. It was a confidential exhibit that they did not receive. But that's the method and manner in which it's been submitted. And it is new since COVID, because they used to hand deliver them to the court prior to COVID. And Wayne County Probate Court is not an e-file court in the sense that they use my file, but they kind of turned into an e-file court via an email system since COVID. So that's, the procedure there.
Well, Ms. Santa Marina, let's not focus on process. Let's get to what I think is a clear violation of a court rule. MCR 5.121 D2A says, quote, any interested person shall be afforded an opportunity to examine and controvert reports received into evidence. How is this procedure consistent with that?
I don't know that it is or isn't, because I've not seen a GAL submit a confidential exhibit. My only rebuttal to that argument was that it wasn't raised in the lower court, but I don't know if the court believes that's neither here nor there. That was the only rebuttal I had to that. And I did email the GAL myself as the conservator to try to get a copy of that, just so that it could be, provided, but she would not release it to me either. And I think I don't have her email in front of me because, like I said, my computer had just crashed when I was waiting. But I think her email from memory insinuated that there was something in there that kind of insinuated they were scared of what the minors had said to her that would make the appellant angry. But again, I'm going off memory, so I apologize if I'm misstating what her email said. But I think it was an exhibit to my brief.
So nobody's seen this exhibit. No one in this proceeding, including the person defending, has seen this exhibit. That is just very troublesome. But go ahead, Judge Yates.
I guess now that I've seen this argument made twice, that somehow a clear court rule can be overridden when somebody might be upset by the contents of the report, seems to me an entirely indefensible position. Is there any explanation that you can give me? I know you haven't seen it either, so I'm certainly not upset with you about that. But is there any explanation you can give me for why this court rule would have been written the way it was if the kind of concerns that seem to justify ignoring it have merit?
Unfortunately, Your Honor, I cannot. The only thing I could think of would be that the court is trying to preserve the confidential record from becoming part of the public record, but that would not, preclude the parties from having the ability to review it. To be quite frank with you, I hope that makes sense. There could be like a reference in camera review or something of that nature. And I wasn't at this hearing. Obviously, you all have read the transcript, but there could have been some sort of in-camera review of it as opposed to filing it in a way that it would become part of the public record. The only thing I could think of is the court was trying to protect it and the GAL from becoming part of the record that anyone could view.
Well, right. I certainly agree that it shouldn't be marked as an exhibit and admitted into evidence and somehow placed in the official court file. But I don't know how anybody can just disregard something as clear as the language of this court rule. And at least in my experience, the court rules generally are written by people who are experts in those areas. And then those drafts are presented to the Supreme Court for adoption. I mean, it's not as if some random person just came up with this language.
Well, Your Honor, if I may be, I guess I don't know how to phrase this, but working as a probate attorney, the probate court is kind of like the wild, wild west. And maybe I shouldn't say that in an appellate court because it's going to be in a transcript. But, things just kind of go a little differently there. And I'm not saying that's correct or just, but it is just it's a little different having practiced in federal courts and circuit courts and, court of appeals. Things are a little bit different there, but I'm not justifying or excusing the court or what it did or the GAL. It's just, for those who aren't familiar with the probate court, that's kind of how it is.
So counsel, I mean, hypothetically, do you see a problem with a pronouncement of some sort that the court rule must be complied with? I get that you have an issue about whether this has been properly preserved, although you can see by our animation how this just seems rather unbelievable.
Of course. And I think that if this court were to issue some sort of guidance that, as Sister Counsel had said, that would be 100% appropriate and quite frankly, maybe necessary as it relates to argument one.
All right. Thank you. Any additional questions? All right. Thank you very much. Appreciate that. Ms. Parker, anything for rebuttal?
I would simply echo Ms. Santamarina's comment that the probate court is a little bit like the Wild Wild West. And I think that's where you end up seeing these types of things happening. And I want to back her up as co-counsel in that regard. I handle civil appeals. I do a couple of random criminal appointed appeals just to make myself feel good about life. And I do probate appeals. And I will say, of those courts, it is invariably from the probate court that we get these unique situations that you just don't seem to see in other forums.
Thank you for that candor, and frankly, the probate judges, they do God's work and they deal with a lot.
Yeah.
So maybe just having something out there that formally advises of the procedure would be helpful for the trial courts as well as the practitioners and the parties they represent. Thank you both. And I think that we're good from our end.
Your Honors, if I may, I didn't want to interrupt because we're on Zoom proceeding, but just procedurally, to just, and I'm sure the Court of Appeals has considered this. I just wanted to say, depending on whatever the court's decision is, I already am in possession of the funds. They are in a restricted account for the minors. So if the court were to reverse any sort of order, if the court could provide guidance as to what to do with those funds would be appreciated.
We will do our very best. And thank you both for the conversation, the argument, the briefing, and we'll get you some answers hopefully soon. So thank you.
Thank you.
Thank you.
You're welcome. Have a terrific day. And that leaves our last matter, number 11 on the docket number 373574 in Ray Hilson Minors. And that matter is being submitted on its brief. So that concludes our docket here today. I'm going to ask my